there has been a complaint that the entire selection process through the Collegium was opaque and some element of transparency was necessary. While there is no doubt that there is some requirement of transparency, what has been done just now is unfortunately not a step in the right direction. In fact, it has got serious consequences for the concerned candidates.
The recent resolution of the Supreme Court Collegium to publicize its minutes and decisions in the website is a welcome step. When the executive tried to interfere with the judiciary in their appointments and transfers, the Supreme Court zealously guarded the same and installed the system of Collegium in 1993 in the second judge's case. It is subsequent to that there have been certain criticisms because the decisions of the Collegium have always been behind closed doors and the minutes never saw the light of the day. It is this secrecy in the entire process which has resulted in a lot of criticism time and again. Even when the government brought in NJSC as an alternative to the Collegium system, the Supreme Court vetoed the same and quashed it because it interfered with the independence of the judiciary in its view. However, in that very judgment, the Supreme Court agreed to bring in certain amendments to the Collegium system. And now that the Supreme Court Collegium has brought in this step of bringing the resolution in public domain, it is a welcome step for everyone.
I saw the disclosures made by the Supreme Court, and there is reference against candidates who have not been selected about adverse IB reports, adverse reports of the Intelligence Bureau. Then there is also mention about the Judges Committee. I don't think it's a right step to inform the public that there's an adverse IB report against a particular candidate. First of all, nobody knows what is inside the IB report. The concerned candidate has not been given an opportunity of explaining any adverse comment in the IB report. Thirdly, the High Court Chief Justice never gets a chance to see the IB report. It's only seen by the Collegium. For all these reasons, it is not advisable. In fact, it is disastrous to mention that a particular candidate has an adverse IB report. Look at the consequences. A candidate may be a district judge, and if there is a report that there is an adverse IB report against him, how does he function as a district judge? The other point is the report is also not very clear. For example, in one particular candidate from the Madras High Court, he has not been selected, but there is no reference to an IB report, adverse IB report. There is no reference to Judges Committee. Just on the basis of a view of one Supreme Court judge, his candidature is turned down.
It is a massive step in ensuring transparency. It instills faith and confidence in the mind of the meritorious members of the bar who aspire to become judges of the High Court and the Supreme Court. It is a role model for the High Courts to bring in greater transparency in their appointments and functioning, and in the matters of appointment of judges to the lower and higher judiciary, and it will improve the actual functioning of the judiciary as such as an institution and improve the efficiency of the bar and the bench. Finally, in my opinion, it will also improve the faith and confidence of the general public in the system as such.
Now, the Collegium of each High Court recommends a candidate after a lot of deliberation. And if one Supreme Court judge from that High Court has an adverse opinion, then that must be put forth to that Chief Justice. And unless that is done, I don't think it's right to turn down the candidate. Otherwise, indirectly, you're giving a veto power to that particular judge of the Supreme Court.